Good afternoon, students. I hope all of you have been well and hanging on in there during online learning. First of all, I would like to sort of recap what we did yesterday because intellectual property topics are relatively new for most of you. So we looked at what intellectual property consists of. We also looked at why intellectual property is quite important for businesses, especially the awareness of knowing how to actually um, obtain intellectual property for any assets of your company is extremely important in the 21st century compared to previous eras. Okay, so if you look at intellectual property, they consist of a whole range of property rights, which are referred to as copyright as well as industrial property. Now, if you look at copyright, okay, it also consists of various types of works, including literary works, musical, artistic works, films, sound recordings, and also derivative works, which means like works that are derived from some other, types of intellectual property or copyright. Okay, so you can see one category is copyright, and the other category is industrial property, consisting of patents, consisting of trademarks, trade secrets. So you can see all of these belong to the category of industrial property. Okay. Now, so yesterday, what we looked at, we started looking at the different types of work that consists of copyright. And we were looking at copyright in terms of the Malaysian law, which is Copyright Act. Okay. Now, so according to the Malaysian law, Copyright Act subsists in literary, musical, artistic works, films, sound recordings, even broadcasts, and sometimes published editions of work, okay, and also derivative works, which could be translations, adaptations, collections of works, but the requirement they must be first published in Malaysia, or the publisher of the edition is a qualified person at the date of the first publication. I explained what this means. Qualified meaning in terms of either he's an owner or he has license to actually publish that work in Malaysia. Okay. Now, so published editions consist of also literary, musical, or artistic works, right? For example, a particular song can be reproduced and published, by different groups of people, right? So that will become a published edition of musical work, right? Or even a published edition of artistic works. Okay. And you also have in this category work of architecture, like for example, the architecture of buildings or structures, right? That would be work of architecture. And then finally, you've got all these government, kind of works, like documents produced by them, and by governmental organization or international bodies. So all of these will come under the category of copyright. Okay. Now, I saw the answers in terms of the quiz. Now, I asked the question whether all types of work are protected for 50 years, and some of you put yes, but the answer is different types of work have got different period of protection. Okay, so for example, for literary, musical, and artistic works, it is life of the author plus 50 years. Okay. Now, if you look at if the author has died and the work was published only after his death, then it is going to be 50 years. Right. So you can see although this is 50 years, and then the next one, if you publish in pseudonym or anonymous, it's 50 years. If it is a published edition, sound recording, and etc., it's 50 years. All right, and so on, right? But you can see that this first category is life of the author plus 50 years. So not all of them are, the same. Okay. Next, okay, if you look at when you are the copyright owner, what are the rights you have as a copyright owner? Okay, so you see the word here, exclusive right. That means only he has this right and no one else. That's what the meaning of exclusive right means. But sometimes the copyright owner may have a joint right. Okay, so for example, if you are the employee and you have published this particular work in the context of your work, depending on your employment agreement, you may have a percentage of that right which you share with although you are the creator, but the owner would be your employer. Okay, but sometimes if the employer gives you a certain percentage, then you become the joint owner with the employer. So then you have, as joint owners, exclusive rights to do certain things in Malaysia. All right, either for the whole work or substantial part of work, either in its original form or in its derivative form. That means, let's just say I actually recorded or I actually came up with a song, right? And then your employer has recorded it. So maybe the recording part of it, the employer has the right, but maybe the lyrics you have the right. You know, so you could have certain parts of the right being owned by different people. Okay, so coming back to the exclusive right, the exclusive right is to do what kind of things, right? Okay, one is to reproduce that material, that copyright material in any form, right? To reproduce that material in any kind of material form, meaning any any format, all right? The next thing is to communicate that material, to perform that material, or to show the material to public. Okay, so the moment you take this copyright work and you actually disseminate it to the public, right? That that part of that right can only be done by the copyright owner or with the permission of the copyright owner. Okay, so next thing is to distribute copies to the public by sale or by transfer of ownership. Right? Transfer of ownership basically means that either you transfer all of your ownership to somebody else, maybe a company that is willing to distribute copies to the public, because sometimes it takes a lot of money to actually make many copies. So maybe the owner, the copyright owner, may not have the financial capacity to do that. So maybe they then would transfer the rights of distribution to maybe a company that has the capacity to actually disseminate it to the public, or to commercialize that particular work. Okay, and then finally the commercial rental to the public, right? Like for example, like you rent out movies and so on. Okay, or like you have Netflix. That's all commercial rental, right? So all of these things are things usually only the copyright owner has the right to do. But keep in mind that these rights can be transferred, right? And they could be actually, or alternatively, you can give license to another person to do these things for a period of time, right? So that is the nature of what do you call it? Copyright rights under the copyright. Okay. Now, so basically now we are looking at all the basics of copyright, right? So you saw what are the exclusive rights. But what are the rights that are excluded from copyright protection? Meaning, what are the things not covered by the copyright protection right now? As I've indicated earlier and as pointed out by the videos, the copyright does not protect ideas. Right? It's only the expression of ideas that copyright protects. What's the reason why copyright law does not protect ideas? Because if I don't allow anyone to use these ideas, then the society cannot progress. So it's always a balance between the ownership rights of the person who had the copyright and public benefit, right? Because ideas, if you keep it as a secret, society cannot benefit from it. So that's the reason why copyright doesn't protect ideas, but only the way ideas are expressed. Okay. Copyright also does not protect systems or business methods. All right, systems meaning any kind of systems. Like for example, diagnostic systems. Copyright law doesn't protect that, or business methods. Okay, so copyright does not actually, the scope of copyright doesn't cover business methods or systems. It'll be covered by some other intellectual property systems. Okay, now, so you give an example. Copyright law does not protect your ideas and graphs, right, expressed in the original business plan, but the words that you use to describe your ideas, right? And what do you call it? And the way you describe your graph, right? Or the way you have explained what your graph means. Now that part of it is protected. Okay, so that is excluded from copyright protection, right? It doesn't protect ideas. It doesn't protect the graphs that you have put in your business plan, but the way you have explained it, explain your business plan, and the way you have explained your graph, okay, the words that you have used to do so is going to be protected. Okay, now we have covered the basics of copyright. We are going to now look at its application in e-business. All right, and for all of you, this may be something that you need to have a basic understanding about. All right, now if you look at e-business, or any e-business, it has got two areas that they must be particularly concerned about. The first is, if you are going to develop a website to actually sell your products or services, then you must make sure that your website is protected from potential infringers. Infringers are people who are going to, violate your copyright that's associated with the website. That means they may be copying things from your website, all right? Either parts of it or all of it without your permission, right? So the first, what do you call it? The first thing that you should do once you have designed the website is to see how to protect it from potential infringers. The next thing you need to do is to make sure that you yourself are not infringing anybody else's copyright material, right? Because sometimes you will upload things in your website, but you have to make sure that these materials do not belong to someone else. Now, if you really do want to, use material from somebody else, another owner, then you have to obtain permission from them. Okay. Now, sometimes your website may contain links to another site, right? So when you link to another site, that site will have also copyrighted material, all right? So you have to be very careful when you put links in your website that links to another website which has got copyrighted material, and you can't use those, or even though you're just linking it, you may indirectly be committing copyright infringement. So again, you have to be very careful when you are setting up websites. Okay, now, if you look at e-business websites, it consists of various combination of materials, all right? And these materials are for the benefit of the consumer or potential consumers. And these materials contain information, right? That's what they call it, information content. And basically, you're communicating this information to consumers, right, in the form of either words, right, graphics, audio, and video. So that means basically every website will have these categories of information in the form of words, graphics, audio, or video, right? Now, so either you develop the website yourself or you hire someone else through contract to develop the website, all right? Now, so again, even though you are hiring someone else to develop the website, you must have an idea. And when you're checking the end result of whatever the website has, whatever the developer has come up with, you must make sure that all of these words, graphics, audio, video that they have developed for you is not violating anybody else's or is not infringing anybody else's copyright. Okay, so you have to carefully vet, okay, the content, before you actually upload it and then use it for your company's product or services. Okay, now when you look at the subject matter expressed in the website, right, usually it is an electronic publication of content, right? So it's like e-publication, all right? So whatever that you are expressing in the form of words, in the form of images, and so on, they are actually electronic publication as opposed to say hard copy of it, right? And so it's a bit different, right? So because it's electronic publication, you can actually register your website for copyright protection. Okay, so other than the separate materials and whom they belong to, but your entire website, the look and the feel of your website, the colors that you use, the sounds that you use, all of that together as a whole is entitled to copyright protection. All right. Of course, the condition is it is original and it is creative. Okay, why I say original? That means it's not a copied work from another website. Right? It's an original work. And then second, it has some form of creative content. Creative meaning you have actually used some effort to produce something that is unique and based on your creative effort. Okay, so this is the condition: original and creative. Okay, now the next thing is you have to make sure that you legally protect the content ownership of website. Okay, the content ownership of that website, because if you remember, when you actually develop a website, there's a lot of designing, producing, and then after you design and you produce all that information in the website, you have to maintain it. All right, this website, this electronic commerce website, and if it involves elements that are interactive, remember the sliding rule, the more interactive a particular website is, the more liability you will have. All right. So again, you have to be very careful to protect the content ownership of the website. All right. Some websites just give information, they don't interact with you. that's not so difficult to maintain. But when it is interactive and there's a lot of, there's a high, should I say, high volume of people coming and visiting your website, right? And a lot of people are, interacting with your website, of course, then it becomes all the more important for you to, register for copyright protection of your website, so that others will not, copy and, without permission, whatever information you have actually put in your website. Because why? At the end of the day, you have spent a lot of money to actually develop this website, all right? And, for the purpose of, marketing, as well as for the purpose of selling your products and services. Okay, now, the next thing is there's lots of legal consequences, all right, that will arise later, and you must understand that, you have to, continue to make sure that, others don't copy your website, and you didn't take any part of your website from somebody else without permission, right? So and then you have to continue to update, right, your, e-company's website. Okay, so these things, all have some form of legal, consequences, right? So it's very important that you are aware of these things. Okay, now, so if you look at the, e-businesses that you have, all right, you have to come up with a appropriate, legal strategy, right? So what would your, legal strategy be? The first one is your e-business objective, okay, is going to be protect the web pages of the company's website from being copied by other companies, and also protect your own company from being sued by others, right? So these are the overall goal, because the moment, others copy your information that you have, created or developed, right? You have spent money to hire someone to develop your website. Somebody else is just coming, copying, and then, for free without letting you know, right? Of course, that's going to affect your business. Secondly, if others are going to sue you, again, it is going to affect your business. So either way, your e-business objective is to make sure that your web pages are protected. Okay. Now, so what would the legal strategy be? Okay, the first legal strategy is to register the copyright of the web page. Right? That's the first and most important legal strategy. The next is, within your website, you must make sure you include disclaimers. Okay, what is a disclaimer, right? In the terms of use for copyright infringement by linked companies. So that means you put in, a term saying whoever who used this, you are not responsible if some harm comes out of it, or, this information is just for the purpose of this thing, not for the purpose of, have you seen sometimes they put, this is not legal advice, this is just information. If you want information, you need to go to a lawyer to obtain, legal advice, but the information in this website is just, purely for the purpose of, information, and not any form of legal advice. So that's an example of a disclaimer, right? Or something like, if you use this product, okay, and, if it, like you follow a particular if you use a particular product, and if certain, things are not as it is, or certain things didn't turn out as expected, then the manufacturer can say they're only going to be responsible for up to 1 year. After that, they will not be responsible. So, they say disclaimers like that. That's an example. So you put in terms in your, website, they call it terms of use for copyright infringement, and that would, with words that disclaim your liability, or that says that you will not be liable for certain things, right? So that is what a disclaimer is, right? And then you also finally need to monitor bulletin boards, e-bulletins, and chat rooms for particular businesses, because you will know that people are talking about certain things about your product, about your services, and then you will you basically get to know who may be people who are potentially going to infringe information in your web pages and so on. Okay, so these are the three strategies. Number one, register your web pages. Number two, make sure that in your website you've got terms of use for copyright infringement, and include appropriate disclaimers. And then finally, you monitor what's happening in bulletin boards and chat rooms, because this may be a bit difficult for you to do, but nevertheless it's quite important for you to do, right? So that's that. So okay, now what is the criteria for copyright protection of a web page? Right? The first criteria is originality. As you know, copyright protection is only available for original works, not copied works. So the first criteria for copyright protection of your web page or your business's web page is that it must be original and it's not copied from another website, or an adaptation of another website's work. Maybe you just change the colors and or change the words a little bit here and there, but overall it's pretty much a copied work. Okay, like sometimes a lot of students, they produce papers, you can know straight away it's a copied work, right? It's not original, based on the words you use and so on, right? So again, one of the most important things for website protection is that it is original, creative, and so for the creative part, you should strive for a unique presentation, right? Next part is the creativity, right? So if you look at creativity, okay, you may think, what's the difference between being original and being creative, right? So basically means that it is, like the design or the whatever that goes in there is something that you have thought out for yourself, and you have created with your own, say thinking process or thought processes. So what you have is your creative effort, right? Of course, normally when things are from their creative efforts, it's usually original. So the originality and creativity is very much interrelated. Okay, so usually when you create something out of your own effort, right, it would be original. Okay, then finally, remember, copyright ideas, you have to fix it in some medium. So it must be in fixed form. Right? So the moment you actually fix it on a website, right, that would be in a fixed form and therefore entitled to copyright protection. Okay, so again, criteria, originality, creativity, and is in a fixed form. And with the moment you put it on a website, it definitely meets that criteria that it is in a fixed form. Right, next thing, right? If you look at most copyright works, it has what you call the constitutional protection. That means, the copyright laws of any country usually comes under the purview of that country's constitution. So, for example, the United States Constitution gives Congress, right, the authority to make copyright laws, right? Under Article 1, right, Section 8, Clause 8, for the purpose of what? To promote progress of science and useful arts. Okay, so this is quite interesting, because you can see copyright law and most intellectual properties are there for the purpose of promoting the progress of science and arts, right? And the Federal Constitution of Malaysia also, gives the right to make copyright laws to the Parliament, right? So I think if all of you remember, when you talk about governments, there are three branches of government. One is the executive branch that usually implements policies and enforces laws. Then you have the legislative body or the legislature that makes laws. So in the US, the body that makes laws is at the federal level is the Congress, right? In Malaysia, the body that makes laws at the federal level is the Parliament, right? Now, so here in the federal constitution, the right to make copyright laws is given to the Parliament and not the state legislative assemblies, right? And that authority is given under Article 74, Schedule 9, Section 8D. So the right to make copyright laws is in the hands of the Parliament. Okay. Now, once again, what are the rights of the authors who produce copyright works? They have the exclusive property interest for a limited period of time. So that means the moment you register your website, you've got the exclusive property interest or proprietary interest over the website for X amount of years, right? So that means for that period of time, the owner will have exclusive control, all right, over that website, all right? They have a monopoly. Monopoly meaning only you have the exclusive right. Nobody else have that right without you giving it to them or without you giving permission to them to do something with the work created by the author, right? So basically, that's what happens when you register your website. You've got the monopoly over that work for X number of years, all right? X number of years, meaning uh, the, the duration of protection is for that period of time, okay? Now, so basically, if you look overall, you look at copyright interest, there's always, whenever you give rights to anybody, right, there's going to be a conflict of interest, right? So here too, you see there's a conflict of copyright interest in World Wide Web, right? So the conflict of rights or the conflict of interest is between whom and whom. Of course, the first would be the author, right? The author's interest, the author's rights will be conflicting with what other rights, right? The rights of whomever who is using the World Wide Web. The whole purpose of the World Wide Web originally was to promote the free flow of information. As you know, originally World Wide Web was associated with academic sector, the academic world, where people wanted to exchange ideas and information when they're doing research. So that's how World Wide Web first came about. But now the World Wide Web is used for many, many uses, and some of them are commercial uses as well. So here you have a conflict of interest on one hand of protecting the innovation, and the creativity of the authors, whatever efforts that they have put into to come up with a copyright work, and that is conflicting with the culture of World Wide Web, which is to promote the free flow of information. Right now, the other thing that interest that is problematic is what you call freedom of speech, freedom of expression. Right? Again, if you look at the World Wide Web, it is to encourage the free flow of information, to encourage people to express their ideas, and so on. Now, this freedom of speech is protected under the First Amendment of the United States Constitution, right, which says that every citizen of the United States has got the freedom of speech. And this is very important. In fact, it's the First Amendment. That is the very First Amendment of the United States Constitution says that everybody who is the citizen of the United States have got freedom of speech. In our federal constitution in Malaysia, on the other hand, is Article 10, subsection 1, subsection A, all right? Comes under the liberties part of the constitution, and it talks about freedom of speech. And okay, so for in both cases, in both constitutions, the whole idea is to encourage the expression of ideas. However, as all of you know, the importance of freedom of speech in the United States and the importance of it in Malaysia is, very different, because it could be also in terms of history, in terms of culture, in terms of many things. You'll find that the importance of freedom of speech is, relatively lesser, I would say, in many developing countries, including Malaysia. Okay. Now, if you look at in the context of commercial sector, right? Again, it's very important, for commerce to thrive. You need new information. You need creative information. You need the latest information for the development of commercial expression and growth in the commercial sector, right? And so ultimately, if you look and see, the aim of copyright laws and the federal courts is to balance between these competing interests. Okay, on one hand, to encourage creativity, all right, and the development of commerce, and on the other hand, to encourage the free flow of information, right? So it's very important that the laws and the courts do this very delicate balancing act. All right, now what are the potentially, should I say, areas that as a e-commerce you should be concerned about? Of course, any business, any e-business will have to hire, employees. And sometimes your employees who may not have adequate awareness of intellectual property rights, they may forward or attach copyrighted email without consent of the author, okay? And therefore violating the author's exclusive statutory right to copy. So, like we do that, right? Sometimes people forward us information, right? And then we just forward it without making sure it's okay or not. So when your employees do it, you, the business owner, may become liable because they are forwarding maybe materials which have copyrighted, email, correct, or copyrighted information, and you, when you forward it without the permission of the author, you are infringing the author's right to copy, right? And then the other thing is uploading information and making multiple copies of online material. So sometimes what we do, we get information from another website, and then, like, for example, lecturers do that a lot, right? We will upload videos, we upload articles, we upload, information, and we sometimes, upload it so that students are going to make multiple copies. So here you have got so many types of infringement happening, right? And you can be legally liable. Okay, now, a lot of the time, people from this part of the world, from, say, for example, Malaysia, they think, well, how are they going to find out? How would somebody in US know that I am doing this? Well, unfortunately, when you are dealing with the internet and then you are downloading and uploading, as you know, your computer have got IP address, and if they are tracking, they can track all this, whatever that you're doing, right? So then you expose yourself to liability. Okay, so downloading MP3 files, all of these are activities that potentially infringe the rights of the copyright owner. Okay, okay, so it's very important for the courts to actually interpret the copyright within the current environment of information technology. So it's very important that you see what the current environment is, and then you interpret the copyright laws according to the latest developments in terms of IT or information technology. And the courts have to respond to these changes rapidly, all right, or respond to it accordingly. Otherwise, they are behind time. So sometimes the laws don't keep up, and the decisions of the court do not keep up with the very fast changes in IT. Then the law becomes outdated, right? And then, of course, as always, you have to maintain the delicate balance of the rights of the owners with the public's right to have access to information, right? So the protection of original work does not extend to the following, as I've said before, doesn't protect ideas, it doesn't protect procedures, doesn't protect processes or systems or method of operation or concept, principle, or discovery. Okay, so copyright law only protects expression of idea, and then when it's fixed on a particular medium, such as web pages, and that would give it the right for copyright protection, right? Either it's in a web page or in the form of some form of storage devices. Okay. Now, so normally, if you register in US, you register your copyright, you get a certificate of registration, and then the certificate becomes proof that you are the owner, right? And then if somebody infringes the copyright and you take him to court or take her to court, then this certificate becomes proof of ownership, right? Now, you look at US always like to do it a bit differently. In most parts of the world is life plus 50 years, but in US they've given additionally another 20 years is life plus 70 years for works created after the 1st January 1978. Okay, now I will stop here, right? And we just have got a few more slides, but anyways, I will stop here, and then we will continue in the next class. Hopefully you have understood it sufficiently. If you don't, like I said, you could either text me and or give me a call. All right. Um, I may try to do a live online session next week, right? But I will keep you posted on that. Okay, thank you.